I have been informed by staff that around 11:20 there will be 3 votes on the floor, and these will be the only votes of the day. However, if the chair would like to proceed with his questions, and we will get as far as we can before we have to go for a vote. But I would also like to ask the witnesses if they could possibly remain until we come back from the floor where we will be voting. The chair recognizes himself for 5 minutes. I'd like to get for each of you on the record on a very basic question. Do you believe that TSCA needs to be reformed? And please answer with a yes or no, starting with my guest and my friend, Mr. Stevenson.
Yes.
Mr. Davis.
Yes.
Ms. Swanson.
Yes, Mr.
Mr. Mark, Coleman Mark.
Yes.
Mr. Rank.
Yes.
All right. I've heard some suggest that the problem here is not really the statute, that the problem is the EPA's interpretation of the statute. It seems to me that after 30 years of failed efforts to carry out the law through many different administrations of different political stripes, it is fair to say that there are some serious problems with the statute itself. Do you agree with this conclusion?
That it's EPA's interpretation and not the law itself? Was that the question?
No, we have some serious problems with the statute itself.
Yes.
Okay. Mr. Davis?
Yes, I do agree.
Ms. Swanson?
Yes,
Mr. Coleman Mark?
Absolutely, I agree.
Mr. Wright?
Yes.
Okay. Let me ask you another question, be as brief as you possibly can. What are the top 2 or 3 areas of TSCA that you think are in most need of reform? And please state, follow with your reasoning, and be very as brief as you possibly can. Did you hear my question?
Yes. We think the evidentiary standard that we talked about is too high. I think there's room for better sharing of information to the public. And I think that the burden of proof for safe chemicals is tipped entirely on the government right now and should be moved more to industry. We're not here to endorse REACH. We're only using that as an example where the chemical industry is required to provide information to show that the chemicals are safe. We think it can be risk-based. We think it can be production volume-based. But nevertheless, the way TSCA works right now, it's in 30 years, it's just proven so burdensome that it doesn't serve its purpose.
Mr. Davis, would you care to respond?
I agree with Mr. Stevenson. Let me make 2 quick comments. One, in terms of the evidentiary burden, it's different from what's in almost all the other environmental statutes. I mean, arbitrary and capricious is the standard used in almost all the environmental other statutes. And in TSCA, it's substantial evidence on the record, which is an incredibly high burden. And when you combine that with the other requirements in the Act, that's enough to undermine everything. The other thing is, again, I would just urge the committee to pay some attention to things like nanotechnology and synthetic biology, which are coming down the track very fast. The regulatory system is not equipped to address those kinds of problems. And we have to try to think through what changes are needed to address those things.
Thank you very much. Ms. Swanson?
I would agree that a major area for reform is to shift the burden of proof from government and proving that a chemical is toxic after it's on the market, shift that to industry proving that a chemical is safe before it goes on the market. That's just a key element that needs to be reformed. Also, we would like to see neurodevelopmental testing specifically included as the toxicity, as part of the toxicity testing that is required by the statute.
I think that the one-by-one review approach of chemicals that is under TSCA sorely needs to be reformed. Many low-income communities and communities of color are not impacted by chemicals on a one-by-one basis, but through their multiple and synergistic effects. I also think that the fragmentation that TSCA provides for chemical policy is really bad. The fact that some chemicals are regulated in the workplace and some chemicals are regulated in food and some chemicals are regulated in cosmetics, and they're all regulated differently is a problem. Chemical is a chemical is a chemical. And then lastly, the whole notion of sort of the risk-based approach with which chemicals are dealt with under TSCA is a problem. From our standpoint, risk models do not often include people of color, they don't include women, and they often don't include children. Some of the most vulnerable populations, given some of the things that I've talked about in terms of the communities that I work and organize in.
Thank you very much. Mr. Wright?
Well, I agree with all of the above, but let me add to the list the great trade secrecy burdens that really prevent people from getting much information about the chemicals to which they're exposed. I also think that a new statute should require a lot more testing. Most chemicals are tested really only for their acute toxicity and not for chronic long-term effects. And I think we need a combination of a risk-based and a hazard-based approach. That is to say, the reporting should be the reporting by a company of the intrinsic hazards of a chemical that they produce, whether it's acutely toxic, whether it's a neurotoxin, whether it causes cancer. And after that's done, after we have that information, which we need to evaluate the risk, that's when you look at risk, and that's when you look at how you actually deal with that chemical.
Thank you very much. The chair now recognizes for 5 minutes the ranking member.
Thank you, Mr. Chairman, and again, appreciate the testimony of the panel. Let me start off by saying I know firsthand on the issue of chronic disease and diseases for which you cannot take a pill to get an immediate cure. I deal with that in my family as we speak. So I understand fully, Ms. Swanson and Mr. Corbin-Mark. I'm empathetic with your issues, and I care about the same things that you care about. However, I just want to make sure that whatever's done in something like this has to be based on good science, and it has to be done in such a way that doesn't cripple a good industry. And I think those are the points that I think that I'd like to leave you with, to make sure that whatever's done in a law that is generally accepted, the fact that it needs to be updated and reformed, that we don't do it in such a way that we cripple an entire industry that's legitimate out there. So I guess, Mr. Stevenson, if I could ask you a question. There were 80,000, either 80 or 82,000 chemicals registered.
80,000 on the existing chemical inventory.
It's 80,000. Mm-hmm. In your view, do you think that the industry, the chemical industry, should be on the hook to prove that every one of those, by good science, is a safe material? Do you believe that under the law that the industry should take on every one of them and then come back with?
I don't think you can apply a one-size-fits-all to everything. That's been the complaints of the European approach under REACH, that they acquire too much information on some chemicals that are known to be safe. So I'm not a chemistry expert, but I think there are ways to segment that family of chemicals into those where the chemical industry should be required to provide information and those that should not. I think EPA has even offered to scrub the list in some way. They haven't done that, but they could do that.
And also in your testimony, was it the number 200 that were 200 chemicals that were...
Where they actually required additional information from industry, and there's a burden of proof on EPA and a case that it has to go through and years that it takes even to get that. So in 30 years of TSCA, there's been 200 times where the law has worked to require additional information.
Okay. In your view of knowing what you know about the industry, can you give me a sense of, because we're looking at 200 to 80,000, somewhere in between there, a sense of the chemicals that are out there that need to be looked at further?
The catch-22 that Mr. Davies pointed to is the biggest problem. EPA is required to prove the chemical is dangerous, and it needs information to do that. Well, who has the information? The person who produced it does. So they can't meet that burden without information from the industry. So there has to be more of a collaboration here for EPA to get the information that it needs to do its job more easily than it can right now.
Thank you. Ms. Swanson, you mentioned a list of chemicals. I got, the same 80,000 that are registered. Of course, that's common. 3,000, and then 10 that were proven. Can you go over that list then and kind of give me an idea of what you're talking about in the overall chemical world of all those registered on TSCA? How many things we're looking at here?
Yes, I mentioned that of the 80,000 that are registered, about 3,000 are produced at more than 1 million pounds annually. So these high-volume chemicals, there are 3,000 of those, which might be one good starting point for requiring information. And of those 3,000, we know that 10 are neurotoxins, and there is good evidence to suggest that another 200 are neurotoxins.
Are those 10 neurotoxins that you know of for sure, backed by good science and still in products today, being manufactured into products today?
It's backed by a very good body of science that, that in many cases stretches over decades. Some of them are not in, well, lead is one of the main and most potent neurotoxins that we know about, and so lead has been gotten out of a lot of products, certainly.
Yes.
But then some of the others are still being used in products today, such as the chemicals that come from combustion. Those are used in products today. A lot of the solvents are known neurotoxins, so compounds that are used in products like lighter fluid and oils and paint strippers and thinners. A lot of those chemicals are known neurotoxins and are still being used. So it varies. PCBs are a known neurotoxin that has been banned. So some of them we've gotten rid of, and some of them are still being used.
My time is expiring, but I just look forward to further questioning after we get done here, but I would like to go into a little bit more about, a good idea that the devil usually becomes in the details, and when you do these regulations, how they can have an unintended consequence on an industry that drives up the cost of purchased goods and such too. So there's another side of this thing that I'd like to continue discussing on when we get back. Thank you, Mr. Chairman.
I recognize Mr. Sarbanes for 5 minutes of opening statement, 5 minutes of questioning.
Thank you, Mr. Chair. Ms. Swanson, you said in your testimony that many people would be, particularly parents, would be, I think you said, dumbfounded and then outraged to learn that there isn't more oversight and data available with respect to these chemicals. And I'm frankly becoming dumbfounded as I learn more about what hasn't happened as a result of what the expectations were of TSCA. And I'd be very interested to hear from anyone who wants to comment on it briefly, because TSCA was hailed in the day when it was passed as this huge step. What happened? In other words, what expectations for what it was going to do were not met? And how different is the oversight environment now as a result of the passage of TSCA, given the interpretations of it, compared to the way things were before it was passed?
I mean, I'll take a stab at part of it. The evidentiary standard we talked about, just the use of the term unreasonable risk in a legal sense bears a very high evidentiary burden, one that EPA can seldom meet. And that's why the asbestos case is important. They finally spent the 2 to 10 years that it took to make the case that it needed more information, only to have it thrown out by the courts by not meeting that high evidentiary standard that's spelled out in the rule. That's why, as a minimum, we think that kind of language needs to be modified.
Just in terms of the history of the act, basically the sort of fundamental trade-off made when the act was formulated under the Nixon administration was a set of very broad and sweeping authorities in exchange for a bunch of very high procedural hurdles. And the court decisions since then, particularly corrosion-proof fittings, which is the 91 decision, made it very clear that, in effect, those broad and fairly sweeping authorities to take action were undermined and negated by the procedural hurdles. So
basically, it sounds like it's a lot of it has to do with the judicial interpretation subsequent to the passage of the act, which is not, I mean, that's not an unusual thing to happen. You have expectations of what will be changed, and then once it gets into the court system, things get more nuanced. Let me move on real quick because I got 2 minutes here. I was curious, what other are there analogies to on this issue of the burden of proof, which now resides heavily on EPA to prove that something's unsafe, versus on the manufacturers and so forth to prove that it is? Are there analogies to other statutes administered by the EPA where you see that sort of what I would call imbalance at work, or is this one of the more egregious instances of where you've got the burdens flipped in the wrong direction? I mean, that's my view of it, but
the two most egregious examples in my mind, in addition to TSCA, are cosmetics and dietary supplements. In both cases, the burden of proof is entirely on the agency, in that case, Food and Drug Administration. Furthermore, the statute, in effect, prohibits any kind of adequate oversight, which is even further than TSCA goes. But TSCA is definitely, if not the most important, definitely one of the most important examples where the burden of proof problems interfere with the effectiveness of the statute.
thank you. I yield back.
The Chair thanks the gentleman. I think that we will stand in recess until we return from the votes, and we again ask the witnesses if they will remain for the conclusion of this first panel. Thank you. Chair is in recess.